In what could be the biggest legal war in the entertainment industry since Napster, Hollywood titans Disney and NBC Universal have sued AI image generator Midjourney for what they call straight up theft of some of their most well-known characters, from Spider-Man and Darth Vader to Homer Simpson. So how important is this lawsuit and what is likely to happen? Hi, James Pacitti, entertainment attorney in Los Angeles. Disney and NBC Universal have launched a landmark copyright lawsuit accusing Midjourney of functioning as a virtual vending machine that churns out near identical versions of iconic characters, without, of course, permission from the owners of those characters, Disney and NBC Universal. Many in the industry are already saying that this lawsuit will determine whether the studio system survives. This lawsuit is likely the first shot and was likely going to be a larger war waged by the legacy studios against artificial intelligence. The lawsuit strikes at the heart of whether AI's use of copyrighted materials, especially for training, qualifies as fair use. Disney and Universal argue it doesn't, calling for legal limits on AI's current modus operandi, which is for AI to be trained on existing copyright protected material, claiming such training and its output is fair use under copyright law. This is a precedent-setting lawsuit, as it is the first time major studios have sued an AI art generator, signaling that large-scale copyright is non-negotiable, even for emerging tech. The lawsuit could formalize standards for licensing data and filtering outputs. The lawsuit could also have an impact on AI in content creation. AI tools have been embraced in pre-production, visual effects, and concept art, amongst other areas. But Hollywood has remained cautious, and this lawsuit may prompt studios to invest in licensed, purpose-built AI rather than relying on unvetted open source models. There also will likely be ripple effects on talent and intellectual property. Unions like SAG-AFTRA have already been negotiating protections for actors' likeness in AI. This case could bolster efforts to protect creative labor, influence agreements that influence AI's use in filmmaking. The outcome of this lawsuit, win, lose, or settle, will determine the future of studios and content creation. Will studios continue to do what they do, incubators and generators of film, TV, and other entertainment content, or will they morph into IP rights managers? In conclusion, this lawsuit isn't just about stopping AI from copying Shrek or Darth Vader. It's about establishing the legal framework for how AI interacts with creative IP. For entertainment, this could mean stronger IP protection for studios, creators, and talent. It could also be a pivot toward licensed, compliant AI tools. It also could provide clearer contractual guidelines for AI usage and a potential boost for supervised AI models that respect creative investment. Whether the court sides with Disney and Universal or with Midjourney, one thing's clear: the rules of AI and creativity are about to be rewritten. If you have any questions about this topic, or if you have a project you wish to discuss, don't hesitate to contact us.